Hi everyone, welcome from Law with Dunk, the Lantern Law Guide today, as ridiculous as I look. And today is day 40 of the Case a Day series journey, covering cases across criminal law, tort law, contract law, and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. Also, just a big well done and good luck to not only my A-level law students, but all A-level law students across the country. One down, two more to go. Keep your heads up and keep working hard, and it'll all be worth it when it's over, especially after what I imagine has been 2 tough years. And then have an enjoyable summer. Now back to this recording. In the day 38 recording, we looked at subjective recklessness and the case of R.V. Cunningham, 1957. And in the day 39 recording, we looked at the old and now overruled test of objective recklessness and the case of MPC v Caldwell, 1981. So Metropolitan Police Commissioner v Caldwell, I believe, 1981. Today, I'd like to continue to explore the issues with objective recklessness and focus on how these were present in the case of Elliott v C, 1983. Remember, from what we covered in the day 39 recording with the case of MPC v Caldwell, 1981, the House of Lords stated that recklessness could be used in two situations where both would apply. That's very important here, where both would apply. The first situation being where the courts entertained the subjective test, i.e. where the defendant had realised the risk of an outcome occurring and went on to take the risk, and the second being the courts also entertaining the objective test too, i.e. where an ordinary, prudent, so aware person would have realised the risk of an outcome occurring even if the defendant had not considered it. Very important there. As established in the day 39 recording, the problem here was this second part of the Caldwell test, i.e. the objective test, as where a defendant was not capable of being subjectively reckless and therefore couldn't appreciate or realise the risk involved from his behaviour, he or she could still then go on to be deemed automatically objectively reckless as a reasonable person, also known as an ordinary prudent person, may still have realised there was a risk, which was always unfair upon defendants, especially extremely drunk defendants, as in the case of MPC v Caldwell, 1981, as the reasonable person isn't someone who is extremely drunk. The issue with objective recklessness presented itself in Elliott v C, 1983, where the defendant, a hungry and tired 14-year-old girl of low intelligence, so she had learning difficulties, who was out alone and cold one night and had wandered into her neighbour's shed, was not subjectively reckless for the crime of arson due to not appreciating the risk and going on to take it under Section 1 of the Criminal Damage Act 1971 when pouring white spirit on the floor of a shed and setting it alight and thus starting a fire that spread and burnt down the victim's shed along with its contents. Here, even though the defendant, a 14-year-old, wasn't subjectively reckless after being found not guilty at trial, it was eventually held on appeal in the Court of Appeal that if the risk of arson in this case was one which would have been appreciated by a reasonably prudent person, or ordinary prudent, so aware person, then despite her being 14 and having learning difficulties, none of her subjective criteria would be relevant. She would be deemed automatically objectively reckless and therefore be found to have the mens rea for the crime of arson and be found guilty, which we can see is extremely unfair on the defendant here. Here we can see that it is absurd and ridiculous to judge her according to the standards of reasonable or ordinary prudent adults, which is the problem with objective recklessness perfectly demonstrated here, as she is found guilty despite not being at fault. And that's it for today. Thank you from Law with Dunk, the Law Guy, and I'll see you Friday.